Okay. Very good evening, students. Very good evening, Manik. Manik, please confirm about the audio and the video in the comments. राधे राधे मानिक. वेरी गुड इवनिंग मीनू. ऑल गुड मीनू. आप बताइए कैसा है? ओके, थैंक यू मानिक फॉर क्लैरिफाइंग दैट. वेरी गुड इवनिंग स्तुति. चलिए, ओके, परफेक्ट. And if that is fine, we are ready to go. Okay, students. So if you all are ready, quickly give me a thumbs up. On that note, I'll start the session. Quickly give me a thumbs up. I'll start the session. Chaliye. Thank you very much. On that note, let's begin with this class. So first of all, I welcome each one of you to my class on the Indian Penal Code. Let's start with my brief introduction. My name is Sandeep Khatri. These are my areas of specialization, as you can see on the screen. Here is the link of my profile. So make sure you follow that to get all the updates about my special classes and my plus courses. This is the link of my Telegram channel where you can connect with me. And at last, I have mentioned my code, that is Khatri10. I request everyone, please be attentive, and this is going to be interactive session. Now coming to today's class, what we are going to do. So students, we have started a new subject on YouTube, that is the Indian Penal Code IPC. And this class is going to be about section 1 till 160. So first I will start with some questions. If you have any questions, if you have any queries, anything which is not clear to you, any basic concept, any section number, any illustration, any case law, if something is not clear to you in relation to IPC, you may ask your question. Okay, ji? And after that we will do some MCQs as well on section 1 till section 160. Yes, please. Anyone having any questions? Very good evening, Mamta. Good evening, Adarsh. If it is all clear, then quickly give me a thumbs up, then I'll ask some questions. Mamta, that depends कि कितने hours की class होगी. Somewhere around 45 minutes to 1 hour maximum 1 hour. ठीक है जी? Okay, first opportunity I am giving it to you all. अगर किसी को कोई क्वेश्चन नहीं है, फटाफट quickly give me a thumbs up, then I'll ask some questions. Okay, perfect. चलिए, if you don't have any questions, then I'll start the MCQ test. चलिए जी. Okay, all clear. So students, जो भी क्वेश्चंस अभी हम करने वाले हैं, these are the most basic questions from IPC. ये काफ़ी repeated questions हैं आपके एग्जाम्स के भी. तो on that note, let's start with this test. Who drafted IPC? Yes, choose the most appropriate option. Who drafted IPC? ओके, इस क्वेश्चन से रिलेटेड और जितने क्वेश्चंस बन सकते हैं वो भी हम साथ साथ में ही कवर अप करेंगे. ओके, एवरीवन इज राइटिंग बी. टॉप 3 स्टूडेंट्स टू आंसर करेक्टली, मानिक, पलक एंड नेहा. ओके, बी इज द करेक्ट आंसर. ओके, टेल मी if the question is who drafted IPC and the options are first law commission, second law commission, third law commission, fourth law commission. Which law commission drafted IPC? Be quick in your responses. Which commission drafted IPC? Okay, first one to answer Prashant, after that Mamta, and immortal. Everyone is writing First Law Commission. Can anyone tell me what was the relationship between First Law Commission and Lord T.B. Macaulay? Now the third question. What was the relationship between Macaulay and First Law Commission? My third question is, what is the relationship between First Law Commission and Lord T.B. Macaulay? President. Okay, head. Okay, you can write all the answers. He was basically the chairperson of First Law Commission. ठीक है जी? So Lord T.B. Macaulay was the chairman of First Law Commission. Now there were other 3 members as well. Can you please write the names of other 3 members? Yes, please. Okay, Neha has already written Millett and Anderson. We are left with only one. Millett and Anderson. We are left with only one now. Anyone? Millett, Anderson, we are done, Palak. Who was the third one? No, Nirmal. Okay, let me tell you. Now I'm concluding all the questions. Who drafted IPC? First Law Commission. Who was the chairperson of First Law Commission? Lord T.B. Macaulay. Who all are the other 3 members? Millett, Anderson, and MacLeod. These were the other 3 members. Done? Okay. Next one. Which one is not an essential for crime? Bataiye ji. Which one is not an essential for crime? Okay, first one to answer immortal, then Manik, after that Sapna. Okay, everyone is writing D. Okay, perfect. Okay, D is the correct answer. Okay, ji. So let's come to another questions which are related to this one only. Whether this term person has been defined or not. Fatafat, write down the section number of term person. Section number of person. Sapna, first one to answer, section 11. Okay, whether mens rea and actus reus has been defined in any of the sections? Whether mens rea and actus reus is defined in any of the sections? Okay, Vartika, first one to answer, not defined. Okay, immortal and Mayuri as well, not defined. Okay, whether the term person includes human being as well? Please answer. Whether the term person under section 11 of the Indian Penal Code 1860 includes human being as well? Okay, Vartika is saying yes, Manik yes, Mayuri is saying no, Stuti yes, Ritu no. Okay, there are 2 students who are saying no. Vaishali is also saying no, Neha no. Okay, there are some students who are writing yes as well. So basically there is a confusion, right? Okay, anyone can tell me the reasons for their answer? Whatever your answer is, yes or no. I'm repeating myself. My question was whether section 11, the term person includes human being or not. Some are writing yes, some are writing no. My counter question to all of you is, please tell me the reason of your answer. Madhur, just wait, I'll explain that. I have not received even a single reason till now. Manik, I'm looking for reasons of your answer. It says not only a natural person. No, Stuti. Mayuri, no, as it only includes body of persons. Okay. 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 Now let me answer, let me clarify this doubt to each one of you. Now listen down this. See, when you read section 11, there is nowhere it is written human being. But when you will read section 11, there is a term which has been used, and that term is includes. Includes means inclusive definition. Inclusive definition means the definition given under section 11 is not exhaustive, and if the definition is not exhaustive, it means it may include some other thing as well. And what are those other thing? The first another thing is human being. If you are one of those students who are saying ki sir, human being is not under person, then you tell me whether a human being can commit an offense or not under IPC. If you are saying person does not include human beings, so you are basically saying that human beings cannot commit crime, because the very first essential of essentials of crime is person. So the concluding answer here is the term person includes human being as well. Now the reason is because it is an inclusive definition under section 11. I hope everyone is clear with this now. जिन्होंने यही सेम रीजन लिखा था, इमॉर्टल, वंडरफुल, बेस्ट ऑफ लक. ठीक है जी, आप देख सकते हैं काफी सारे कमेंट्स आ रहे हैं, तो एक दो कमेंट्स हो सकता है मेरे से मिस्टेक हो जाए, मैं मिस कर दूं, सो जस्ट प्लीज इग्नोर दैट. ठीक है जी, बट आई होप नाउ एवरीवन इज क्लियर विद दिस. नाउ मूविंग टू द नेक्स्ट क्वेश्चन. मेंस रिया मीन्स, I don't think you should find it this question difficult. One of the easiest question you can expect in the exam. The meaning of the maxim mens rea. Okay. Everyone is writing guilty mind. I don't think there is any confusion on this one. Moving to the next one. With reference to crime, response the following. Crime is a civil wrong, state wrong, private wrong, none of the above. Students, a humble request to each one of you, before writing your answer, first write down the question number. Like for example, if you are writing the answer of this question, write down 4 and then whatever you feel like A, B, C, D. ठीक है जी. Okay, everyone is writing B, and B is the correct answer. Crime is a state wrong. If you are done with law of torts, you must have heard about this, that the tort is a civil wrong. ठीक है जी. And when it comes to crime, it's a state wrong. And this is one of the reason when there is a civil suit, it is on the name of the two parties, right? Plaintiff and defendant. Done. Mr. A versus Mr. B. But when it comes to a crime, when it comes to an offense, it is always like the state or the union territory at which the offense has taken place. For example, state of UP versus the name of the accused. And this is the reason, because it's a state wrong. Next one. We are already done with this. Who drafted IPC? Now, coming to this. Word referring to acts includes illegal omission under section. Tell me the section number. Yes, Abhishek, classes regular hongi. All for this month, every day, 7 p.m. on Unacademy Judiciary. Okay, let me come to the main question here. Can anyone tell me what is the major difference between section 32 and 33? Anyone? If you can tell me the difference between section 32 and 33, you can answer all the questions related to these sections. So just tell me, just write down in the comments what is the major difference between section 32 and 33. हाँ जी मीनू, क्लास यूट्यूब पर ही होगी ये। अभिषेक अक्टूबर में भी होंगी, ठीक है, अक्टूबर में भी होंगी। I don't think I have received the correct answer till now. Good try, Vartika, but this is not the difference. Or maybe you are not able to express it. See, this is the thing. At the time now, see, try to learn something from here. Right now, I am asking a question. Similarly, you are going to get some questions at the times of mains examination. And if you are not able to write it here in the comments, so how will you write in your mains examination? Okay, now let me tell you the difference. Okay, so now I'm telling you the difference. First, coming to section 32. Section 32 states that act includes illegal omission as well, which means if there is an illegal omission, that is part of the act. This is the first thing. When you will read section 33, this will tell you that act includes series of act. Illegal omission includes series of illegal omission, which means a singular act includes plural acts as well. A singular illegal omission includes plural illegal omissions as well. This is the major difference. Fine. Now moving to the next one. Choose the most appropriate option. Neha. Neha, you may choose some better words, but yes, I've read your answer. That's the correct one. Okay, first one to answer correctly, Abhishek, Sanskar, and Agent 47. Okay. Madhur Singh, start reading illustrations as well. This is basically illustration of section 19. Okay, so as per to section 19 illustration, I guess this is the last illustration, if I'm not wrong, illustration D. Okay, you don't need to remember the illustration number, by the way. Okay, or if you can only recall that it is the case of illustration, that is more than sufficient for you. Now coming to the answer is not a judge under section 19 of IPC. Okay, ji. Now can anyone tell me what is the reason? What is the reason? The reason has not been written down under section 19. So if anyone can tell me the reason why this particular magistrate has not been considered as a judge under section 19. Anyone? You must know the reasoning as well, right? Why so? Not give decision. Okay, Sapna. Only frame charge. Not apply judicial mind. He is not deciding the case. Okay, Sapna, not giving decision, and Agent 47, not deciding the case. I'm taking these answers. Is not acting judicially. Okay. Fine. Okay, most of the students knows about this. जिनको नहीं पता है उनको मैं बता देता हूँ. The reason behind this is because of the concept of committal. What do we mean by the term committal? Committal means you just take the cognizance and then transfer the case to the judge who is actually going to try that case. For example, when it comes to murder, now how will you get to know that who is going to, having the trial of the murder? The answer lies in Schedule 1 of CRPC. So it says court of session. Now, but who is going to take cognizance? The magistrate is going to take the cognizance, and after that he is going to commit the committal, and the case will go to court of session. So the judge of the court of session is going to be a judge as per to section 19 IPC, not the magistrate who is just taken the cognizance. I hope everyone is clear with this. Next one. Okay, this is very, very easy. I have a difficult question for you. First, just answer this one. You must remember the section number as well. Injury has been defined under section. Okay, perfect. The answer is 44. Now let me give you one application based question and let's see if you can answer that. So suppose a police officer is doing an arrest, and that arrest is completely lawful, but the person who is getting arrested, he is showing some resistance, and in that resistance he got hurt. Now you tell me whether that hurt will fall under the definition of injury under section 44 or not. Yes, please. अभिषेक, कल का किसी को नहीं पता है. I'm going to take class on a regular basis on YouTube. Fine? Happy? Right? Then, so don't worry about that. I'm going to take classes on YouTube. This is just the first day. And this is the first class I'm taking now. After a very long gap, by the way. Okay, now I'm reading your answer. Sanskar, no. Agent 47, no. Okay, one student has said yes. Neha, yes. No, yes. Okay, students, try to develop one more habit. Whenever you are answering, whether it is a yes or no, obviously one of them is the correct answer. So better start writing the reasoning as well. Okay, if I am saying yes, these are my reasons. If I am saying no, these are my reasons. Right? So now answer to my application based question, the correct answer is no. Can anyone tell me the reason as well? Vartika, your reasoning is correct, but a keyword is missing in your answer. Your reasoning is correct, but a keyword is missing. And if the keyword is missing in your answers, then it is going to hurt you at the time of mains examination. Illegally caused to any person. Bahut badhiya. And this is what I called hitting the bullseye. Stuti has completely, highlighted the key point, illegally. Right? So there is a keyword that has been mentioned under section 44, which is illegal. And in my application based question, the police officer is just doing a lawful act. And if you are doing a lawful act, then you cannot cause injury to anyone. Right? So that is why the answer is no. Wonderful, ji. Bahut badhiya, Stuti. Next one. It's a maxim, one of the most famous maxim. You cannot get this wrong. Actus non facit, riem nisi mens sit rea. What is the meaning of this maxim? ओके विशाल, आप जो भी टॉपिक्स चाहते हैं वो मैं यूट्यूब पे कवर अप कर सकता हूँ. आपकी जो क्वेरी आपने लिखी है मैंने पढ़ ली है. ठीक है जी. सो डोंट वरी अबाउट दैट. आप जिस भी टॉपिक्स पे जो भी आप क्लासेस मुझसे चाहते हैं, आप वो मुझे टॉपिक्स बता सकते हैं ऑन माय टेलीग्राम चैनल. ठीक है, मैं क्लास के एंड में भी अपना टेलीग्राम चैनल आपको एक बार दोबारा से उसका लिंक शेयर कर दूंगा. तो अगर आप उस पर लिखेंगे तो मैं वही क्लासेस यहाँ पर कंडक्ट करूँगा. डन. Okay, everyone has answered A. Chaliye ji. So the answer A is correct. There cannot be a guilty act without guilty mind. Now my counter question to each one of you who have answered question number 9 is are there any exceptions? Yes, are there any exceptions of this rule? Guilty act without guilty mind. Yes, tell me, are there any exceptions? Okay, Vishal. Okay. Parminder, 376. Parminder, it's 375. Okay, 376 is the punishment for kidnapping. Okay, sedition. Okay, so you basically knows. So there are exceptions to this rule. Okay, and the list is again not completely exhaustive, but yes, bigamy. Okay, bigamy, rape, traffic regulations, food adulterations, these are the examples. Or ignorance of law is no excuse. Okay, offenses related to weights and measures, these all are the exceptions. Okay, where you don't require any kind of mens rea and you will get punishment as well. Okay ji, we are already done with this. Yes, this one is interesting. Section 31 defined the term. This should be defined, not defines. Section 31 defined the term. Choose the most appropriate one. Question number 10 we are already done, so that's why I have skipped that. Yes, public nuisance is also, contempt of court is also, these all are the exceptions. Or basically you can say the strict liability as well. This one is a really special question, trust me on that. These kind of questions basically challenge you that how attentive you were while you were reading the Bare Act. Now you may get confused, and I can see there are students, some are writing C, some are writing D, most of are writing D. Fine. So the correct answer is A will. And trust me, this is not my question. This is one of your previous year questions. So basically that's why I say repeatedly, when it comes to PT examination, it is all about, your how much time you have spent with the Bare Act. And the correct answer is D, A will. It is not the will, it is A will. Okay ji? Done? Next. This is again a maxim, a famous maxim from the criminal law. This falls under Constitution of India as well, in your fundamental rights. Yes, B is the correct answer. No crime of punishment can exist without a pre-existing penal law. Article 20 of the Constitution of India. In which of the following offences guilty intention is an essential element? I have a good question on this one. First answer this one, and then I'll ask a supported question on the same concept. Advocate Ronit, right now I am taking plus classes on CPC, contract and partnership. Okay, everyone is writing B, and yes, B is the correct answer. Now my counter question to each one of you, can there be a situation where there is no mens rea and still it will fall under theft? I'm repeating myself. Can there be a situation? Can there be an exception where there is no mens rea but it will still amount theft? Yes, please. Your answer may be yes or no. Better write with your reasons. Okay, Aishwarya, first one to answer. Yes. Sapna, yes. Meenu, yes. Parminder, yes. Abhishek with his own. Come on. Okay. First one to answer correctly, Abhishek Kumar. Vishal Rohila. Correct answer. Students, always do remember this. There are no exceptions. There are no exceptions. You know, the basic concept of theft is there must be dishonest intention. Right? There are no exceptions at all. And if you think there is, please do write down. I'll comment here only. Anyone? Parminder, if the person has taken his own property, even in that case, if that person has dishonest intention, he may commit theft. Let's take an example. You came to my house and you are asking ki, sir, I need a book for 3 days and I gave it to you. Now I am coming to your house and I, with dishonest intention, moves that property into my bag so that I can, claim further. Okay, where is my book? So even in that case, I am committing theft. Okay, there are no such exceptions. Fine. Chaliye. I guess I may move to the next one. Very easy. The term injury under section 44 denotes any harm, whatever illegally caused to any person in. I think the easy one, Vartika, Parminder, completely correct. D is the correct answer. Easy one, right? Next. Which cases are related to mens rea? Okay. 15, the answer is A. When it comes to cases related to mens rea, the only case that has written here is R versus Prince, a landmark judgment. Birendra Kumar Ghosh, Mehboob Shah, both are related to section number 34. The term dishonestly is defined under section. Again, easy one. These are the direct questions. You just cannot get these wrong. Yes, R versus Tolson is also a landmark judgment on mens rea. I have a very interesting question from there as well. R versus Tolson. R versus Tolson falls under the exceptions of mens rea. No exceptions. No, not exceptions. There is altogether a different concept. But yes, there is the question of mens rea also has been asked. Yes, Saraz versus D. Rudson as well. Okay, ji. Easy one, section number 24. Now this one is interesting. I hope everyone has gone through with the details, the facts, the issues, the decision and the reasons that has been taken under Mehboob Shah versus Emperor. Landmark judgment on section 34. Now I'm asking, who was the judge? Who was the judge in Mehboob Shah versus Emperor? Choose the most appropriate answer. This is again one of your previous year question. I guess this has been asked in Uttarakhand Judiciary, if I am not wrong. Abhishek, first one to answer correctly. Lord Sumner was in Birendra Kumar Ghosh. Okay. For Mehboob Shah, it was M. Nair. You need to tell me which section is this one. Which section is this one? Yes, Abhishek, these all are the Privy Council judgments before independence. Yes, Neha, R versus Tolson will also fall under bigamy. बहुत बढ़िया. Sivash knows the complete name as well. So this is basically your section number 6. Okay. So B is the correct answer. Actus reus. The meaning of actus reus. Wow. So Abhishek has attended one of my classes. Yes, that's my keyword, bridge. Bridge between chapter number 4 and all the your offenses and their punishments and their illustrations and everything. Okay. B is the correct answer. Consequences of human conduct forbidden by law. Attempt is Chaliye. I'm happy that you remembered. First one to answer, Vartika. Immortal B. Okay. Okay, there is a lot of confusion on this one. Vivek is writing B. Most of the students are writing C. Chaliye. Now let me answer this, students. Section 20, question number 20. Attempt is sometimes punishable, completely wrong. If you are writing B, that is the wrong answer. Reason, punishable only. This is the problem with the option number B. Punishable only when there is any specific provision of attempt of that particular offense. No, there is section 511, and because of this only, option number B is wrong. The correct answer here is the most appropriate as per to all options are always punishable. Why it is always punishable? Either in the specific provision or in the section 511. It is never punishable, it's a wrong one. So the correct one is always punishable. Done? Vartika, Prashant and Sapna, top 3 to answer correctly. Abhishek, the correct answer is A. C, the keyword here is offense. Consequence was committed within India. Consequence was committed in India. So there is no question of extraterritorial. Fine. So is liable. Which one is correct? Is liable or can be held liable? The answer is liable. If someone has committed offense within the territory of India as per to section number 2, that person is liable under IPC. So IPC has all the jurisdiction over that person. So the correct answer here is A, is liable, right? Section 3 of IPC deals with A, B, 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 C. I'm getting mixed responses on this one. How can you get this wrong? Which one is section number 3? Always do remember, intra-territorial jurisdiction. This is section number 2, extraterritorial jurisdiction. This is section number 3. B is the correct answer. Extension of extraterritorial jurisdiction. This is basically section 4. Okay, and suppose if you are getting a question in the examination that which one is extraterritorial jurisdiction, and the options are section 3, section 4, then they both are obviously the sections of extraterritorial, because there is extraterritorial in section number 3 and there is extraterritorial in section 4. But what is the major difference? It is extension of extraterritorial. Okay, section 3 is always read with section number 4. Next one. Vartika, Prashant and Abhishek, top 3 students to answer this correctly. The correct answer is in Mumbai, and the reason is section number 4 illustration and section number 188 of CRPC. D is the correct answer. You should not take more than 10 seconds to answer these kind of questions. These are very, very, very easy and direct one. Whether it is a concept or the section number. Okay, I have an interesting question in relation to this one. First you answer 26. Okay. Everyone is answering D. The correct answer of section 26 is D. Now my counter question to all of you is, when it comes to section 26, voluntarily means knowledge, reason to believe and intention. There is or there is and written between these 3 words. There is or there is and. Which one is mentioned between these 3 concepts? Or and. Prashant Rai, first one to answer correctly. Or. Chaliye ji. Or is the correct one. Always do remember that. Life under section 45 denotes life of. It is only the life of human being. A is the correct answer. Section 52A deals with which concept? Vaishali, Vartika, B. My God, Parambir, Vaibhav. Section numbers याद नहीं है. The correct one is harbor. Section 52 deals with good faith. 52A deals with harbor. I can see there are many students who are not able to recall the section numbers. Common intention signifies pre-arranged plan. How many punishments are there in section 53 of IPC? B is the correct one. Okay, what if I change the question and the options remain the same, but what if I change the question? How many punishments were there in section 53 originally in IPC? Originally in IPC, and these are the same options. Originally I am talking about now. First one to answer correctly, Vartika, Sapna. Okay, let me make more difficult for you. The same question, but again a twist. Which punishment has been omitted? Please listen down the question carefully. Which punishment under section 53 has been omitted? Under section 53 omitted. Which punishment? Yes, please answer in the comments. Which punishment has been omitted? I have not received the correct answer till now. I have not received, I am repeating myself. I have not received. Okay, Aishwarya, I am checking your answer again. No, Aishwarya. If you are writing transportation or life transportation, that is not the correct answer. Prashant, Nirvasan, I guess कि एक हिंदी टर्म है, तो आई एम नॉट अवेयर कि इंग्लिश टर्म का जो करेक्ट आंसर है ये उसी की जो है वो है ट्रांसलेशन है. Come on. The correct answer is penal servitude. Always do remember, if the question is asking about substitution, then the correct answer is transportation. If the question is about omission, omitted, then the correct answer is penal servitude. Okay. Okay, यही है. ठीक है जी. अगर हिंदी में इसको यही कहते हैं निर्वासन, तो फिर मतलब you are the only one who has answered correctly for this one. ठीक है जी. So I hope the other students will now keep remember this. ठीक है जी. Five more questions to go. Total 35 questions. Vartika Abhishek. Parminder. Aishwarya. Not the correct answer जी. ध्यान से सुनिएगा. This question can be asked in two senses. The first one is this one. If the children has been involved, it means the last essential of section 80, which is proper care and caution, that has not been fulfilled, which means there is no defense, the person will get the punishment. Why? Because all the essentials of section 80 has not been fulfilled. So which punishment he will get? Section 304A, death by negligence. So B is the correct answer. No murder, no culpable homicide, and no offense, which means no defense. Okay, ji? So he will not get the defense. So obviously he will get the punishment, and punishment under section 304A. Okay. Next. The most easiest one, you cannot get this wrong. B is the correct answer. Okay, these are the only 32 questions total. Now, anything which you are not clear with, you may ask. And if it is all clear, quickly give me a thumbs up. I'll wrap up the session. Yes, Dolly in CapEx, section 82. All done? Punishment wala bata do. Okay, Parminder, listen carefully. When it comes to section 53, it states various punishments that may be given under IPC. Fine. So originally there were 6 punishments. Fine. Done. Now there are 2 punishments which has been amended. The first one, penal servitude, that has been omitted, that has been deleted. Done. And the another one was transportation, which has been substituted with life imprisonment. Okay. Now what is penal servitude? This is basically the next level of hard labor imprisonment. Okay. This is the next level of rigorous imprisonment. So that was penal servitude, which is now omitted. But when it comes to transportation or life transportation, that is now substituted with life imprisonment. I hope now it's clear. Please confirm. Parminder, waiting for your confirmation. Question number 31, Vartika. Okay. Vartika, if your answer is no offense, it means you are giving defense here. ठीक है जी? It means you are giving, okay, everyone listen down this carefully. If your answer is no offense, it means you are giving the defense here of section number 80. Now you tell me, when you give the defense of section number 80, when all the essentials of section 80 has been fulfilled. Now which one is the last essential? If you read section number 80, the last essential is proper care and caution, which means whatever you are doing, you know, the lawful act, lawful manner, lawful means, that you are doing it with proper care and caution. But as per to this question, if children were playing around, and you were still, cutting the tree, it means you have not taken proper care and caution, and just because of that, we are going to give you the punishment of death by negligence. Okay, that is section 304A. But suppose there are no children playing here. There is one person who was sitting on the bench, and in the illustration only there is one line has been written that there is no need of proper care and caution. And if in that case that person died, now that will amounts to no offense, because the person Mr. A will get the defense of section number 80. I hope it's clear. डन वर्तिका? चलिए जी, if everything is clear, so this is the link of my profile, my Telegram channel where you can connect with me, and this is my code Khatri10. Okay जी. Yes अभिषेक, आपने देखा होगा घर में भी जब कुछ ऐसा काम हम करते हैं जिसमें कुछ खतरा है तो हम बच्चों को पहले दूर कर देते हैं, क्योंकि बच्चे कभी भी उसमें हाथ वाथ कुछ ना कुछ डाल देंगे, तो हम उनको अलग कर देते हैं, विच मीन्स वी आर टेकिंग प्रॉपर केयर एंड कॉशन. लेकिन आप बच्चों को साथ में बिठा के वो काम कर रहे हो तो बच्चे तो फिर गलती कर ही देंगे, और अगर बच्चों ने गलती कर दी तो इट मीन्स यू हैव नॉट टेकन केयर प्रॉपर केयर एंड कॉशन, तो आपको डिफेंस नहीं मिलेगा, एंड देन डिफेंस नहीं मिलेगा तो फिर पनिशमेंट मिलेगी, तो पनिशमेंट कहाँ मिलेगी? 304. चलिए जी, on that note, thank you very much. Let's crack PCS J with Unacademy, and that's it from my end. See you in my next class. Till then, yes, it's time to say